So, I want to welcome everyone to an incredibly important topic, and you know that because you're here today. But why are contracts needed for all businesses? Jeremy Bombard has been a presenter for our group in the past, and we're very happy that he's here with us today to share what he knows. So, as we get started, I just want to do a quick review of Boston Business Mentors and what our goals are. So, we are here to help all small business owners, whether you're in the planning phase, the in business phase, growth phase, or exiting your business phase. We have mentors that can help you. What does a mentor do? A mentor listens to what you need. It might be a soundboard. It might be help getting things on track. It might be help with a plan to reach a certain goal. Many different things. They're flexible to what it is that you need to be successful, reach your goals, and accomplish your business. So we also have our workshops and webinars certainly posted on our website and then through our newsletter. I'm adding new topics every week, and we have some really great ones. So please take a look there. Information on the website, on the resources. You can find lots of great little blogs that we've added and our resource and template page. You'll also find on the workshop page, if you scroll to the bottom, you'll find the recorded webinars that of past workshops that we've already had to make sure you're getting the information that you need. So I'm going to pull my share down. Anyway, so I'm going to go ahead and turn it over to Jeremy and let you introduce yourself and start your presentation.
Thank you, Teresa. And again, thank you so much for hosting me. Yes, I've done these a few times for other organizations, and this topic is always very important. Why are contracts needed for all businesses? And I think, if not the most important, but close to the very top. About me, if you don't know me, I am a business attorney, and my focus is working with those small business owners. And my job is the general counsel. And what does that mean? It means when my clients, the business owner, has a legal question related to the business, they come to me. Is it about contracts? Is it about starting the business? Is it about selling or purchasing a business? Or any contracts, anything, we'll talk about those today, but anything my client is going to sign, my inclination and I'm very strong about this is that have me look at it first. Once you sign a contract, then it's much tougher to get out. And spending a little bit of money on me now to have that review and go over the contract, at the very least, tell you what are the pros and cons by signing this contract is going to save you a lot of money down the road. It's going to save you a lot of headaches down the road. Starting my career as a litigator, I was involved in numerous litigations as I am now with my clients. And litigation is timely, expensive, annoying, stressful. And you can avoid a lot of those problems if you get those contracts in order, you have me review them, you make sure that they're signed and you want to sign them. Um, that's the nuts and bolts of my job is to try to keep my clients out of trouble. Uh, the first one is LLCs. And with small businesses, that's the majority of my clients. I'd say 95 of my clients are LLCs. And the key agreement for those is an operating agreement. Now, if you're a single member owner for an LLC, then an operating agreement isn't as important. It is still important to have one because there is case law that says by not having an operating agreement, it doesn't matter if you're a single member LLC or a multi-member, the court says, and this it didn't say this directly, but it basically said we could argue that without an operating agreement, you're not acting as a true LLC. And the reason that's a concern is because the court could pierce the corporate veil. And one of the main reasons everyone sets up an LLC or corporation is they have that legal liability protection. And without that, if you don't have an operating agreement and the court pierces the corporate veil, then guess what? Your personal assets are now at risk in any litigation. But if you're a multi-member, if there are multiple owners of the LLC, you absolutely positively need an operating agreement. It's not it shouldn't even be a discussion. I realize they're not cheap to get me to draft, but again, spending a few dollars now will save you tens upon tens upon tens of thousands of dollars down the road with litigation when more often than not there is a dispute down the road. Um, and it always boils down to usually two things. Who's supposed to be doing what and money, meaning what are people's roles in the LLC? I do impress upon my clients that just because if you own an interest in an LLC, doesn't mean you have to do any work in or for the LLC. You are an owner. That's your job. Your job is solely to collect the distribution every year, if there is any. But if two people are going to form a business, an LLC, and it's going to be to do whatever, run a restaurant or have a daycare center or something as simple as just a simple contracting uh, uh, business. Well, who's going to be doing what? Who's going to be handling the day to day? Who's going to be handling the bookkeeping? Who's going to be doing the actual work? Those are things you would put in the operating agreement. So there's no confusion. Sometimes you have a business where you have a member whose sole job is to have put money into the LLC and they are just a passive investor. They just get paid back their capital contribution over time, and that's all they do. You can't expect them to go and work at the restaurant or work at the daycare or work at the consulting agreement business. Their job was to put money in and then get repaid. And having those descriptions, and it doesn't have to be very detailed, but overall, there should be some discussion about what is everybody doing, how's the roles going to be distributed among the other members, who's going to manage the day to day, because sometimes it's I'm going to run the business and then this other person will just do the actual work. Great. Well, what are those roles and does that percentage of interest in the LLC correlate to that? And then it's the money. Usually, sometimes when you start an LLC, you will put money in to start it, however need be. So you set up a capital contribution account. Okay, well, how is that money going to be paid back? Is this paid back every year, or is this a short-term loan, or does that money get paid back when the company is sold with interest? How does it affect the distributions? Do the members get their distribution first, or does the capital get paid back? Or does the capital get paid back and then the distributions? And when do these events occur? Clients always ask me, they're like, well, when can I make distributions? And my response is whenever you want, whatever you feel comfortable with. Normally, it's when the company starts making a profit. Um, but it could be quarterly, it could be yearly, it could be monthly. It all depends on what the members agree. And it's based on the membership percentage, but it's also who gets that money first? Does it go to the investors? Does it go to the capital contributions? Is it just a distribution to the members? Or are the members paying themselves a salary, so there is no distribution? Does money go back into the LLC for capital expenditures? Those all need to be delineated in this operating agreement to make sure that there's no dispute. When you're meeting with somebody to talk about starting a business, you'll have that discussion and you think you're on the same page, but 6 months, a year down the road, when there's a dispute, when there's an argument, and you say, well, no, no, this isn't what we discussed. Unfortunately, it doesn't matter what you talked about. It matters what you wrote down and described. And again, I can tell you you think you're going into business with your best friend or your family member, and that'll never be an issue. Again, multiple times there's been family and friend issues that pop up. These things deteriorate over time. There's disagreements, and next thing you know, we're in litigation. And that's not fun for anybody. Finally, one of the other key things, especially in a multi-member, is what happens upon the death or disability of one of the members. that person dies, their interest is still there. Now, does the heirs take over the interest? Does that mean if your partner dies in the LLC, are you going to be working with their family? Do you want to work with their family? Is this something the member is doing to provide for their heirs down the road? So maybe it's a situation where you there's a provision where if that member is disabled or dies, then that interest is sold and that value goes to their heirs. Those are the things, again, you should have a discussion. It should be in writing. Um, I do counsel my clients that look, unless you know the new person coming in, that person dies or disabled, and you want to pay out the estate and just be done with it because it just makes your life easier. And that's when things of, well, how do we pay for it? Great. Here's you get some insurance to pay for that. So make sure that when that instance arise, if it arises, and again, you don't know when these things will happen, but it's better to plan for them now as opposed to try to work through them when they occur by not planning for them. So things like that, when it comes to an LLC, those are key. The next one is corporations. Again, majority of my clients are LLCs, but corporations do occur, and they happen a lot of times when it happens a lot when it's going to be either a tax benefit for whatever reason, the industry they're in, the way they're going to set the entity up, corporation tax wise is the better way to go. Or they're going to bring on a lot of investors. It's just easier to have investors with corporations because instead of amending the operating agreement to dictate the shares, it's you just have to do stock certificates. Just to clarify, in relation to legal liability, corporations and LLCs are identical. Um, but corporations, there's a little bit more paperwork involved. You got to get the bylaws. That tells you how things are run, how votes are calculated, what are the powers of the president, the secretary, the treasurer, the directors, who the directors take their clues from. There's also that language of what happens if a member dies, or even how are shareholders allowed to get rid of their shares? Can they just randomly sell them to whomever, or is there a requirement that they get approval by the majority of shareholders? Again, do you just want a random person coming into your company and owning 20, 30, 40, 50% of your company? That's a discussion you should have and decide no or yes. Again, my feeling is whatever the partners, members, shareholders want to do, I'm happy to draft. I will counsel you on some aspects where I feel could be problematic in the future. But again, put it in writing. Something as simple as shares, the actual ownership in a corporation is dictated by shares. And that's a simple piece of paper saying you own 10,000, 5,000, 100,000 shares. Um, I find a lot of my clients, they set up a corporation, they forget to do this step. And I say, well, who owns what? And they'll say, oh, I think we're 50-50. And I say, great, show me where it says that. And they have nothing to show that. Um, if you're 50-50 owners, that's what the court will say. If there's no writings, then it automatically defaults to 50-50. But let's say you're supposed to have 70% and you have nothing proving that you own 70%, then guess what? You don't own 70%. But going back to putting everything in writing, meaning who's going to do what, where's the money going to go, how is the day-to-day going to be dictated? Shareholder agreement is key. Every corporation should have a set of bylaws and share certificates. A lot of shareholders, owners forget that shareholder agreement step. You have to have this document. It's virtually identical to an operating agreement for an LLC, but for a corporation where it says so and so is going to do this every day. This is what these people are going to do. Here's how the money is going to be situated. So and so is putting in $10,000. That's going to get repaid in the first year, depending on, these types of things all in the shareholder agreement. The corporation will take out insurance for these shareholder members. So if one of them happens to pass away, then the corporation has money to pay. Put it all in the writing, put it all in the shareholder agreement. This will make, because if there are issues down the road, then that's always my first question is, what does the shareholder agreement say? If you don't have that, you don't have bylaws, you don't have share certificates, then it's litigation where you have to go to eventually a trial if you don't resolve it to determine what the intent of the parties were at the time of formation to figure out who owns what and what was supposed to happen in case somebody would pass away or somebody wanted to leave. Um, I get a lot of questions of, again, there's a situation where the members don't or the owners don't agree anymore and one wants out. Well, there's always three-ish options, and this relates to a corporation or an LLC. You could, the person that wants to leave, could buy out the other side. Let's say you don't want to leave per se, but you just don't want to work with the other owner anymore. You just don't like them. Fine, you can buy them out. They could buy you out. Those become problematic when, let's say, the value of the company is increased and the other side or even you don't have the funds to buy that person out. You could always sell to a third party if you could find a third party to buy, but those are difficult to find, especially in smaller entities. Um, it's not unheard of, but you just have to find those people, and the language has to allow for the ability for you to sell to a third party. Or if none of those options work, then you have to basically sell the company, dissolve it. And is there writing in the shareholder agreement? Is there writing in the operating agreement that dictate how that works? What the process is if basically at the end of the day, the owners can no longer work, deal, operate with one another anymore. Essentially, it's an entity that just can't function anymore because there's so much um, turmoil at the top end that it'll either explode or it has to be sold or reorganized somehow. And again, what does the governing document say? What does the operating agreement, what does the shareholder agreement say? Does there agreement? Is there a mediation clause? Do you have to go to arbitration? Or at the end of the day, is it just, if the parties can't agree, does that mean it goes to litigation? Um, Courts they don't like to deal with these because it's almost as if the court says, well, look, you should have figured this out. You two are two business people. You should be able to figure this out. I don't want to have to deal with this. Um, so what they'll do normally is they'll just say, fine, you know what? We can't come to an agreement. We're selling it. Get a valuation, put it on the market, you get 6 months, sell it, or liquidate the assets, something to that effect. When it gets to that point, you're not getting the best value for that because you're paying business valuators, you're paying the court, you're paying me, there's a lot of expenses that come up. And at the end of the day, once the court basically dismantles that entity, you're left with something that if you would have come to an agreement beforehand, you would have gotten a lot more money. And the way you come to that agreement beforehand is if you have a good, solid agreement dictating how things are done, if there's a dispute that can't be worked out. So again, first step, you set up an entity, you decide what kind of an entity, and then you hire an attorney to work through those agreements and make sure everything is clear, concise. You work out things that could happen down the road. Are you going to grow? Is this temporary? Is this something for 5 years? Or, is it, I tell all my clients, like, it's just going to be me. I'm like, yeah, until it isn't, until you grow and you want to bring on more people, get those agreements in place so that you don't have to reinvent the wheel. You can add on to those. You can always amend them, but it's tough to recreate them once litigation starts. Um, Client agreements. This is step number two. You've worked, you've got you and your partners are just yourself. You've got your governing documents in place. You're all set. Your legal liability is clear. Now you're going to start bringing on clients. Um, Again, disputes boil down to who's supposed to be doing what, when, and money. And the client agreement alleviates those questions. I always, when I draft them for my clients, there's a lot of boilerplate language that I've used over the years to protect my clients, but also, when an agreement can be terminated and what happens if there's a dispute. I try to make it as easy as possible. But the point I always sit down with my clients with and make sure that there's no confusion is what work are you going to be doing? What is your role and what do you expect from your client? Because sometimes it's not just you doing the work. For example, if I have a contractor who's a client is going to be doing something, well, they need their client to be responsive. They need to sign off on certain plans. They need to assist with picking out cabinets or certain paints or the client needs to make sure that they're not in my client's way. They need to leave a space. They can't touch my client's work. Um, you got to make sure that you as the owner of the business, the person doing the work, has to make sure that your client understands this. It's not just what you're doing, it's what your client has to do as well. Because if your client is difficult and not following what you want them to do, then that just makes your life that much more difficult. And let's say the client keeps moving stuff around the house and you're saying, look, I just can't. And then they say, well, you're not getting stuff done on time. And you, as the contractor, say, well, yeah, because you keep moving everything, I have to restart from scratch every day. Payment terms, you're doing the work, you want to get paid. I mean, that's what I tell all my clients. This is at the end of the day, the end goal is for you to complete the work and get paid. What are your payment terms? Is this a monthly fee? Is this contractors get a third, a third, a third? Do you get paid upfront? Do you have a retainer? Do you get paid at the end? These are the things where the more clear you are to your client, the less disputes you're going to have. I mean, if it's you're saying right here, here's how much I'm going to charge you per month. Here's what I'm doing per month for you. My expenses are going to be billed in addition to that. Then the client can come back and say, "Oh, I didn't know it was going to cost this much." Well, yes, they did because you had the contract, you drafted it, um, they signed it. They know what to expect. Deadlines. When do you expect to get this work done? What happens if there's a problem? What if especially with when COVID happened, there was a big thing about the force majeure clause of the pandemic happened, but if you looked at a lot of force majeure clauses, they didn't have any reference to um, you know, national shutdowns, this and that. And basically people saying, well, no, you got to get the work done. There's no clause in it that says you can't. Um, I went back and my clients and we've revamped it, we worked it. So in case that happens again, there's a way to say, look, I want to do the work, but because of these outside interceding forces, I'm unable to. Therefore, the contract is essentially terminated. Um, Escalation clauses, something as simple as if you're providing a product, but let's say you're saying, I'm going to do this for $1,000. But for whatever reason, the next month, uh, the prices increase, and now all of a sudden you're saying, "Well, great, I'm losing money now." Do you have an escalation clause that expected these events to happen that cost you more money, therefore you can pass those on to the client? Those should be clear, concise, set out. You don't want to lock yourself into a contract where you're losing money. That just that doesn't make any sense for anybody. Because eventually what's going to happen is you as the person doing the work, you're going to get aggravated, you're going to get upset, you're going to say, well, it's not worth me doing it. You terminate the contract. Well, what if it's a 2-year contract? And your client says, well, you breached the contract, you owe me a year's worth of work. So those things of what's going to happen in the future, is there any way, and I'm not saying you just arbitrarily tell the client, look, I'm just changing the price. No, but you at least say, look, if these situations arise, I'm going to have to increase the price. I will give you notice, as much notice as I can give you. But a situation where these things could happen, just be forewarned. Big thing right now is intellectual property. I just drafted one for a client this morning. He does essentially some graphic design work. So what happens is his client hires him, he does the graphic design, um, and then there's stages of doing first stage, second stage revisions. We put specific language in the contract that basically said any work my client does until his client pays him in full, he owns that product. That is his intellectual property. He owns that. He can't give the client a first draft of a graphic. And let's say the client says, "Wow, this is great. Um, I don't want to pay for the updates and the revisions and the finalizations. I don't want to pay another $4,000 for that. I'm just going to take this and start using it." Nope, that's not the way it happens. The language is clear. The intellectual property rights, in this case, stay with my client until my client pays in his client pays in full. Now there are other situations where, let's say, my clients are consulting and they are creating a database or something to that effect. Um, and their job is to create that and do the work on the database, but they're not when they create that database, that's not part of the agreement. They're not giving that to their client. They're keeping that. They're essentially giving their client a license to use their product while my client is working for them. So if they fire my client, they don't get to keep that database. That's my client's property. That's their intellectual property. They didn't pay for that. They didn't bargain for that. That was just a side benefit. They helped out. Now, could there be an agreement that's worked out whereupon that is licensed forever, or is it sold outright? Possibly. Um, but at this point, my client owns that intellectual property. And those are key things. If you're working with somebody and they create something based on your product or time working for you, who owns that intellectual property? That's a big area of contention. It doesn't come up a lot. I mean, you own a restaurant, there's not going to be a lot of intellectual property disputes, but there are situations where it could come up. And my feeling is it doesn't hurt to put it in there. Better to have it and not need it than need it and not have it. Liability limitations. These are my clients always, these are big for my client. They don't want to be liable for something that happens while they're doing the work and get sued for whatever reason. Um, Unfortunately, I tell my clients in this society, anybody can sue anybody for anything at any time. But again, having that liability language is key because if you're saying, look, I'm going to be doing work, you, the client, are going to be working on the client's property, um, you're not liable for something that's out of your control. You don't want for whatever reason comes up, you want to make sure it's clear that your liability is very limited to your role in what you're doing, and anything else besides that is in essence, your client has to hold you harmless for that. And it also goes in with limitations of liability. I always put a clause in that says, if your work is capped at your job is a $10,000 job, someone gets hurt or something happens or there's damage and it's a $50,000 damage claim, you're only limited to a $10,000. Now, again, they're going to sue you. You're going to argue these points. You're going to go through all this. I mean, who knows what the court is going to view these contracts as? I mean, it also depends on everybody's roles. But again, these are things you should have to make sure your client knows, look, I'm coming in to do a job or I'm doing a job. Here's what my job is. I'm not liable for anybody else's wrongdoing or negligence. If you're negligent, then yes, you are liable. You can't contract out over your own negligence, but something with simple limited liability is always key. I will say on a side note, the best way, I mean, again, it's starting off in litigation, my focus is always on how do I protect my clients in the best possible way? How do I make sure that if for whatever reason they get sued, how are they fully protected? And it's a three-step process of making sure they have an entity with all the corporate governing documents. They make sure they do their annual reports. Make sure they have a clear, concise contract, limiting their liability, delineating what their client is supposed to be doing. And then finally, it's business insurance. In fact, that should be step one. Any business, you should have proper business insurance because, like I said, anybody can get sued, even if you have an LLC and a contract. So you just have to go forward and fight that litigation. But instead of paying me, the business insurance will cover that. Um, and you'll be able to save yourself a lot of money with litigation. Finally, in any client agreement, termination. How do you get out of the contract? Um, I have a lot of clients who come to me, not a lot, but I have a few clients come to me and say, "Yeah, I want this 2, 3 year contract." And I say, "Okay, why?" And they say, "Well, then they're locked in with me and they have to hire me. They have to keep me on. They, then it's guaranteed money." And I always say, "Yes, but what happens if you want to get out? What happens if you're working with that person and they're so difficult that it's just unbearable?" Um, or what if, let's say, you work out an agreement where you say, "Look, I'll do this work for $1,000 a month for 3 years," and by the second year, you're way undercharging them. Um, you want to be able to get out. I mean, you don't want them to just terminate. You got to walk that fine line of you as the client doing the work. You want to make sure you're able to get out if the client is difficult or for it's not a good fit or for whatever reason you just want to terminate this contract. Um, but at the end of the day, you want to make sure it's clear that if it does get terminated, if the contract gets terminated, you want to make sure that there's some sort of language in there that says, um, you're going to get reimbursed for the work you've done. I have a lot of clients who do like a preliminary assessment. They get hired. They'll put some time and effort into preparing the first stage of the work. And before that, their client will fire them for whatever reason. But let's say my clients put in 2 weeks of work and a couple $1,000. There's language in there that basically says, look, they get paid. At the end of the day, you do the work, you get paid. That you still have to turn that work product over to the client, but they can't just randomly terminate the contract before a payment date in hopes that they can get something for not paying it. But again, these terms have to be clear, concise. Um, in dealing with small business owners, and I'm positive you have this same issue as well, is that no one wants to read a 30, 40 page contract. You don't want to read it. Your clients don't want to read it. It doesn't make, I mean, you're not doing a multi-million-dollar deal. You're doing something that is 10, 20, 30, 40, 50,000. You want a straightforward, simple contract. And I know clients say, "Well, I don't want to do a contract. My clients don't like to sign it. They don't want to read it. I just want to get the work done." And that works. I mean, that works 80% of the time. The problem is that 20% of the time when there is a dispute, and I tell my clients, look, my focus is when I draft any contract is I want to make it as clear, concise, and as short as possible because I want to make it easy for both sides to read. Again, you don't want, trust me, I've read 80, 90 page commercial leases. They're unbearable. You don't want that. You don't want that for your client because again, you don't want your client to say, "Oh, this guy wants me to sign a 30-page client contract. I'm not going to deal with it." Um, so I get the basics in there. Again, scope of work, payment terms, deadlines, property rights, liability, termination rights, how disputes going to be organized. Those types of things. I mean, a good client agreement is 2.5 pages. That's it. And it gets all the key parts in there. And again, as clear and concise as possible. So again, down the road, if there is a dispute, if there is a people are saying, "Well, no, we didn't agree to this," it's in the writing. Um, that also leads me to if you do have disputes, try to do it by email. And I know texting is very, very prevalent. Um, and it's easy, and that's how people like to communicate. But I will. So this is the problem. Courts don't like it. It's confusing. It doesn't make sense. Um, Judges on numerous occasions, when you present text messages, they say, "I don't. This makes no sense to me," and it ends up being testimony. Um, you know, uh, Again, if once you put things in writing, once you start working with a client, in the back of your head, you should always be thinking, whatever you present in writing, this is going to be in front of a judge or jury someday. Is it clear? Is it concise? Don't use swear words. Try not to. There's nothing worse when you get two people swearing at each other in text and it's in front of a judge or jury. They do not take kindly to that, and more often than not, they just glaze over it and ignore it. So clear, concise, focused terms, those are the best way to get out of any trouble down the road. Employee agreements. In Massachusetts, if you have somebody working for you, 99.999% of the time, they are an employee. They are not an independent contractor. Massachusetts has very strict regulations on who can be an independent contractor and who can be an employee. And I would say 100% of the time, my clients, employees are employees. They're not independent contractors. I know people like to do independent contractors because they don't have to take out taxes and it's easier. And but I tell every client who says I need an independent contract agreement, I will tell them they are not an independent contractor. They are absolutely an employee. You can treat them as an independent contractor and you can hope that you don't get caught. But if you do, then you are subject to fines, penalties, et cetera, from the state. It is not pleasant. I've had a few clients go through that. It is the amount of money they thought they saved by making them an independent contractor, they ended up paying 10 times that in fees and penalties. So, bit of advice, they're all employees. To that end, offer letters. Um, it doesn't hurt to do it. Just again, clear, concise. Here's what you're going to be doing. Here's what you need. I will tell you that the biggest, what you absolutely need for an employee. I mean, you can have an independent contractor agreement. You can have an employee agreement. They say essentially the same thing again. How much you're going to pay them. Although I don't like to be too. You don't want to do that because that changes. That once you put it in writing. So but you want to make sure that their scope of work is there. Um, but the biggest thing you should have anybody working for you sign is a non-solicitation, non-disclosure agreement. Um, non-competition, non-compete clauses, they're virtually unenforceable in Massachusetts. Unless you are a highly specific field, a doctor, a scientist, a biologist, um, or you're buying and selling a company, I tell my clients, don't even bother. They will not be enforced by the courts. However, the biggest thing you should have your employees sign is, or your independent contractors, if you want to go that route, is a non-solicitation and non-disclosure. And what that is basically you're saying you're going to be working for me. You're going to be interacting with clients. You're going to be learning the clients. You're going to you essentially at the end of the day, you're going to get a whole client list. You, employee, cannot quit or get fired in a year, 2 years, 6 months, a month. And then as soon as you quit, set up your own business down the road and call all the former clients and say, hey, I left so and so company, come work for me. I can do a better job. And they're charging you $1,000. I'll charge you 900. Can't do that. Cannot solicit those employee clients. And in that same agreement, that person can't go back to your employees and say, "Hey, quit, come work with me. I'll pay you more money. We'll steal all the clients. We'll do so much better." Nope, can't do it. That's in there. It's clear, concise. No solicitation of either clients or employees, and non-disclosure. Basically, whatever they learn, what the employees learn while working for you. Um, your client list, your policies, your procedures, maybe, some intellectual property and how the service is done. Basically, the confidential information that runs your business, that employee, once they leave, they can't take that information, they can't use that information. They basically have to walk out the door and pretend that they never saw it. There's been cases where what happens is the employee leaves, gets fired, or knows they're going to get fired, or quits, and then the day of, um, a computer analysis shows that they downloaded a bunch of information and took it with them. That courts don't like that. And you want to make sure that's clear. I mean, they shouldn't be doing that anyways, but you want to make it sure in any agreement. And I just did this again for another client just last week. They said they're going to be hiring, I forgot what the role was. And I said, look, get him to sign a non-solicitation, non-disclosure. And my client said, no, 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 they're never gonna, they'd never do that. I said, I, I agree. They most likely will never do that. But at the same time, you do, my client does has a proprietary information of how he operates his business. You don't want your employee to take that and say, oh, I can set up shop or, give it to somebody else. I mean, they can do it and, it doesn't like it prohibits them, but if they do that, then they're liable. Then you sue them and you get a judgment. So something as simple as that, it's again, it's a lot of my clients say, well, I feel bad making them sign this on the first day, or I don't want to overwhelm them. And I said, look, again, I appreciate that, I understand that, but what's more oppressive and annoying and irritating is a 3-year protracted litigation where you spend 50, 60,000 going to trial. You know, spend a couple bucks on me, spend 20 minutes going over it with the employee, and it'll save you a lot of money and effort down the road. Finally, with any employees, and this is key, and because again, I'm your general counsel. I'm the guy that wants to protect you. I don't. In fact, I want to set your company up, get your agreements up, and then if I don't talk to you for another 6 months, that's great. That means everything's going smoothly. Um, problems happen when there aren't agreements or employees. Employees are a big pain point for employers, especially in Massachusetts. Massachusetts is not like small business owners. They will always side with the employee a majority of times. Um, you gotta jump through a lot of hoops. And something as simple as having a handbook is invaluable. You need to have that handbook that says, here's how you're going to run your company. Here's how you're going to treat your employees. Here's what's going to happen. Here's, especially things of if an employee does something wrong, how are you going to um, document that? How are you going to put them on a plan? Is it a first offense? Is it those types of things are key because let's say you do fire somebody and that person turns around and sues you, says, oh, they fired me because of whatever reason. You want to be able to rebut that and say, well, no, look, here's all the times we documented it. Here's all the issues. They were late, you know, half of the time of the year. All these clients complained about them. They were supposed to do X, Y, and Z, and they didn't do that. Here's everything documented. Here's the reason why we fired them. We didn't fire them for a random reason. We fired them because there was a legitimate reason. Because as I said, you go into court and you get sued by an employee, the court's already saying, yeah, the employee's right, the employer's wrong. There's a chance you're going to lose. But if you have a handbook that sets out how everything runs, now again, I have to I have to impress upon my clients, having a handbook is great. You just need to follow it. And nothing drives me more crazy when I say, well, what does your handbook say? They said, well, we're supposed to do this, this, and this. I said, well, did you do that? Did you document it? Did you have the sit down? Did you give them a plan? No, we forgot to do that. Well, again, you spent good money on this handbook, you should follow it. And that handbook will save you down the road. If the employee tries to allege anything, but you're saying, look, here's the handbook, we follow the handbook. Here's all the document, here's all the emails. And again, my clients say, well, just and this again, if you sit down with your employee and you have a conversation, um, you need to do one of two things. One, you should have a memo already drafted, hand it to the employee and discuss what's on the memo. Or after that meeting, you have that discussion, you send them a follow-up email. Because guess what? Again, everything you do, you should be thinking this is going to be in front of a judge or jury. And if there's no documentation, and again, the employee doesn't have to sign off on it. Just if you have something dated and then you can testify, yes, I presented this to the employee. Guess what? That's better than you saying, no, I'm pretty sure we talked about this on this date. And the employee says, I don't remember him saying that. Then at that point, it's whose story is the judge or jury going to believe? But If you have that offer letter, you have that non-solicitation agreement, you have that handbook, you have all the documentation required by the handbook, guess what? There's very little dispute down the road. Document. Again, there's never a situation where I'm telling my client there's too much documentation. Um, it can be cumbersome to keep all this and keep it in order and remember to do this all the time. But again, it's better to have it when you go in front of a judge or jury and you can, because the jury will, documentation is 1,000 times better. If they can look at something and it's signed and it's dated and it's verified, they're going to believe that over testimony any day of the week. So employees, independent contractors should be an employee. Make sure that you have these documents in order because again, um, in fact, next couple of weeks, we're doing an unemployment appeal, where my client basically tried to give, it was a part-time-ish role, and my client was trying to give work to this part-time worker, and they kept refusing or ignoring, and then my client had to fire them, and the person turned around and said, "I want unemployment," and my client said, "No, this is ridiculous. I try to give you work, you wouldn't take it." So now we're going to dispute that. Luckily, my client was very detail oriented. Every time they sent an email or a notification, they documented it. So we have a full documentation of every time my client offered work to this person, it was either denied or no response, and it's clear and concise. Um, Other agreements. Again, anytime you do anything, there should be an agreement. You're going to buy and sell a property. Or not a property, but a business, I think this is without doubt, you should absolutely have some sort of writing. Um, Again, money. What are you paying for this? How much you spending on this? What are you getting? I will draft these, and there will be a list of assets, and I'll send it over to the other side. And next thing you know, they're coming back saying, no, 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 we never agreed to sell this. And my client's saying, well, no, that's the whole point of buying this business because of these assets. Well, great. I mean, we're not even drafted the agreement and finalized it yet. We're already having a dispute. What would happen if you just didn't have an agreement? That would be very problematic. And the other key thing to think about too is you own a business, you sell the business, 6 months down the road, um, you get sued under that business's name, and you're like, well, I sold the business. Whose responsibility is that? You got to make sure those things are perfectly written out in that asset agreement to make sure that there's no doubt. Joint venture is similar to an operating agreement. It's essentially a short-term LLC. If I have two people come to me and say, look, we're going to do this quick project that's only going to be 6 months. We're going to work together. Um, we already own LLCs. I say, look, let's do a quick joint venture. And instead of starting a whole other LLC and going through the process, because you start the LLC, you still have to dissolve the LLC. And there's a lot of fees and expenses of that. But if you and another person are going to do a quick project together, I'll do a joint venture. And this is again, you want to make sure what's everyone doing, what's everyone's roles, what's the term? Is this a short-term thing? Great, 6 months. After 6 months, or once you hit these goals, you're all done. How's the money going to be set? Who's paying the expenses? This person's supposed to be paying this. You're gonna use my office, but so I'll pay the rent, but you'll chip it. Those types of things. Even though it's short term and maybe it's not even that much money, but you want to make sure that there's no doubt down the road or even that in the first week or 2 weeks, you don't want this to blow up so soon into the joint venture. Um, Set it down in writing. My joint venture agreements aren't that long, maybe 4 pages. It's basically, look, here's everybody's roles. Here's how long it's going to be. Here's what happens when we dissolve it. Because these are situations where it's a short term. So, okay, so if you buy something, how's that going to be sold? Is so-and-so going to keep it? Are they going to reimburse the other person? Those types of things, put it in writing, make sure it's clear and concise. I put service and vendor agreements in here. Sometimes those aren't the vendor won't really negotiate. It's a blanket boilerplate form. You got to sign it and go with it. Sometimes they will edit it. Sometimes they will negotiate it. But at the very least, have me take a look because what happens if it blows up and how do you get out of it? How do you extricate yourself? What if the other side's not doing what they're supposed to be doing? What are the ways to basically get your money back? Commercial leases, same thing. Majority of the times, landlords, commercial landlords, their leases are their leases, and they won't really negotiate many key parts. But you got to be clear and concise. Sometimes they sneak in that you got to take care of the HVAC. Well, is the HVAC for the whole building? Then that's not my tenant's responsibility. You want to have things in there that not only will you indemnify the landlord, but the landlord will indemnify you if it's basically negligent. Um, you want to make sure that language is in there because sometimes it's not, and if the landlord does something wrong and you lose your business, if you don't have that language, you can't go after the landlord. And something as simple as for whatever reason, you need to break the lease, you need to get out, something's not going right. You got to make sure there's language in there that says, landlord, if the tenant leaves, you have to make an effort to re-rent the property. You can't just my client can't sign a 5-year lease. The first year they go bankrupt, they leave, not bankrupt because they would leave, but let's say they go out of business, they leave. The landlord can't sit on that property, empty property for another 4 years and then turn around and sue my client for that 4 years. They have to make an effort to get a new tenant in there. Those like I put those in every commercial lease. I just did one yesterday. There's maybe 4 or 5 clauses I put in, just giving my client a little bit of edge. Not much, just a little bit. I will tell you, if you don't pay your rent, you will absolutely lose. Uh, but those little things will help down the long run. Intellectual property, website use, privacy policy, those are terms, these are maybe you don't need them. Maybe you don't have a website. Um, maybe you don't, my clients will say, hey, I want a privacy policy for my website. And I say, well, do you collect any information? They say, no. I'm like, well, you don't need a privacy policy. But if on your website you're collecting client data, you're collecting client credit cards, you're collecting personal private information, how are you using that information? How are you keeping private? How are you protecting it? Those are very big because if you do get hacked, um, this goes back, make sure you have cybersecurity insurance. But if you do get hacked and you didn't follow your privacy policy or your terms of use, guess what? You're going to get hit even harder. But if you followed it all to the T, you did everything correct, there was nothing you could have done about it. You still will probably be sued and you still have to pay some money, but it won't be as much because what you're saying is, here's my policy. I followed it as much as I could. Unfortunately, nothing I gotta do. But again, if you're gonna keep any private information of anybody on your servers, get cyber insurance. I think I can't stress this enough. I've heard from so many IT people that say, look, the little people, the little businesses, and when I say little, I mean, not the multi-billion dollar companies. They think they're protected because why would they hit me? I'm just a little guy. But guess what? You're usually your tech isn't as strong as a bigger corporation. You're an easier target. You get hit. Make sure your client information is protected as much as it possibly can. And there's a procedure that if it does get hacked, you are then able to address it and clear. Because again, if it's completely out of control, then there's nothing you could do. But hopefully you follow everything that you have written down and you have that procedure and policy, and hopefully the litigation isn't as bad. Again, you're gonna go into business to do something with somebody. Make sure there's some sort of writing that delineates what everybody's roles are. Finally, I've been pressing upon my clients more recently is look, I did your client contract 2 years ago. We should look at it again. Laws have changed, things have changed. In my experience, going through the last 2 years, things have gotten a little different. Maybe I'm starting to get away from mediation. I found that just, for small dollar amounts, usually under $50,000, mediation just doesn't, it's a waste of time. So I've been taking those out because you go through the process, you go to mediation, and both sides are just like we're not even close to the middle. So we just wasted a day paying me, a day paying a mediator. It's under 50,000, just go right to litigation. Again, that doesn't say we can't settle it, but mediation just doesn't. Um, or I get a lot of feedback from my clients, like, oh, my clients don't like this section. Can we change it around? Or you have this in here, but it's never come up. I've changed my business model, or I've changed how I do things. Can we update it? Do we need this here? Or hey, I've gotten a lot of these issues have popped up. Other people in my world have said, hey, do you have this clause in your contract? You don't have this? Okay, well, let's look into it. Do you need this? Yes or no? Okay, let's update your contract. Again, you bring on a new owner. Great, we should update that. Have you moved? I do annual reports for some of my clients every year, and I send out the time to do your annual report. Has anything changed? They're like, oh yeah, I moved. All right, well, great. Let's update that. Was that address in your contracts anywhere? Let's update that. I think it's just good practice to sit down, with me, your attorney every year and just say, look, here's my contracts, here's what I have. Here's what's working for me, here's what's not working for me. Let's change it up. Let's fix it up. Again, I'm always happy to talk with anybody about their contracts. And I do this with my clients all the time. Any questions? Hold on.
I do have a question that was just submitted in chat. I can read it
Yes.
out. What are your thoughts on indemnification clauses in consultant independent contractor agreements, such as a short-term project like a training workshop? Is it best in contract for contractor only or mutual for client and contractor? What about a client who doesn't want any indemnification clauses in a contract?
So the short answer is it depends. I hate to say it, but yeah, I mean, I guess look, if you don't have an indemnification clause, are you going to be liable for millions of dollars? No. Um, could a court look at an indemnification clause and say, yeah, I'm throwing that out anyways? Yeah, absolutely. Um, Short-term projects, it depends. It also depends on what you're doing. I mean, if you're just going to be, working on a simple project and, no one's going to get hurt or there's really no liability, then no, it's not really necessary. Um, Sometimes, I've started doing a mutual because I tell my client, look, more often than not, when you send a one-sided indemnification clause, the other side's going to say, hey, this should be mutual. And then I got to go back and change it. Um, and usually it just depends on the work and what the role is. Um, the amount of money. I mean, if you're doing a $10 million commercial real estate development, then yeah, you gotta make sure your indemnification clauses are clear, concise, and you want to make sure if you're hiring somebody um, to do, you're a physical therapist or a massage therapist, you want to make sure that that person they make a mistake, they're going to indemnify you. Although courts will say, well, look, you're the boss. Too bad, so sad. You got to pay. Um, it's one of those things where I always tell my clients, look, here's what I see, here's what you should have. And if the other side doesn't want it, here's the pros and cons. Um, is this a deal breaker? Then walk away from it. But if it's something where we'll sit down and talk and say, I can't see a situation where you're gonna have to indemnify this person or they're gonna have to, so just take it out. If you want the project, then you got to make those decisions of what language you need in there, what language you don't. And I will tell you, here's my recommendation. Here's how I can see this come back and make a big deal in the liability. So let's keep it in. Um, you know, Take it out. Or sometimes my client says, you know what, I don't want to deal with this. It's not that much money. I don't want to worry about this. I'll just walk away. Simple as that. Well, not simple as that, but at the end of the day, it's whatever the parties agree upon, and essentially what I tell you is the best and worst case scenario.
Okay. I do not have any other submitted questions. So thank you very much, everyone, for joining us today. And thank you, Jeremy, for all that information. I will be sending a follow-up email with the recording from today and some other legal workshops that are coming up. So we hope to see you all again very soon. Thank you. Thank you, Jeremy.
Thank you, Teresa. I appreciate it.